Afternoon, ladies and gentlemen. Thank y'all for being in attendance. And you know, this committee is always fun. We always seem to pack a house. And so I will go ahead and ask everybody, including the members, if you would cut your cell phones off. If your phone rings, and there will be a $100 donation to some charity. That's the reason I'm checking mine right now. I can't afford many more Super Bowl games. All right. Ladies and gentlemen, we have several bills today. We're going to try to go through a couple of them. Representative Yates, if you would come forward. This should be a straightforward bill. For the benefit of the committee, I will tell you that this bill has been heard for several years over in the Motor Vehicle Committee. This deals with motorcycle issues. A lot of the motorcycles are too lightweight when they pull up to the red light and the strips in the road. But the strips, you'd think I knew something about this bill a time or two. When they pull up and they get on the strips to change the red light to green, they're not heavy enough to change the light. This says that if a motorcyclist pulls up on those strips and they have been on the strips for not less than 60 seconds, they can look both ways and then proceed. Chairman Yates.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. This started out back in 2011, 2012. Ann Purcell, representative from South Georgia, got it through part of this process, but it never did get completely through. So with her permission, I just copied her bill, and it comes to us today as House Bill 869. And I can just read one paragraph down there. Pretty well covers the chairman pretty well said what it does. Down at the line 17, except as provided in paragraph 2, this subsection, it goes on to tell about it, and down at the bottom in line 22 it said, if a traffic control device or signal is inoperative due to the lightweight design of a motorcycle or other motor vehicle, and the driver has remained stopped from not less than 60 seconds, then the driver may treat such traffic control device or signal as a stop sign, which means, like any time you see to a stop sign, you're supposed to stop, see it's clear, and then proceed carefully. And his or her right to proceed shall be subject to the rules applicable with making the stop at a stop sign as provided for in code section. Nothing in this paragraph shall restrict the permissibility of a driver to make a right turn as provided in the paragraph. And I think somewhere in there, I believe it says that if after you proceed through carefully and you cause a wreck, then you're responsible. The motorcycle or light vehicle would be responsible, as I understand it. Any question, I'd be glad to try to answer.
Any questions from any committee member?
The motorcycle people came to me and asked me to sponsor this bill, and I've got some other sponsors at the top, as you can see.
All right. Do we have any questions from any of the committee members at this time? Yes, sir, Representative Glavin.
Thank you, Mr. Chairman. Mr. Chairman, if you would just help me understand, inoperative, does the signal have to not be capable of operating, or it's just not?
Well, the vehicle is not heavy enough to make it change. If you go, you got to have a certain amount of pressure on these devices that's buried into the asphalt.
Right.
And I was kind of disappointed when they're paving the road down there through Spalding County right now that they don't embed them in there until the job gets completely over. It's kind of frustrating, but that's not the issue we're talking about today.
I guess, Mr. Chairman,
you're right ahead.
I guess I have a light Ford Ranger, and there's a light in my neighborhood that when I get up to it, it won't change. And so sooner or later, I have to make a decision whether I'm going to cross that 138 or not. But I guess the word that I'm looking at is basically saying that if the lighting system is not operating, and see, there is a red light there, it is operating, So I'm a little concerned about that word.
You're allowed to treat it like a stop sign. You go up and stop dead still, look both ways, see that everything's clear, and then you proceed.
One more thought. So if a police officer, I'm on a motorcycle, and I decide to go through that light, and a police officer stopped me, and I tell him that that light was not operating, and I have permission by law to go through it, and he tells me, well, it is operating, it does have a red light up there, what do I do? And not giving you a hard time, I appreciate what you're trying to
If you
do.
waited 60 seconds, the light should change if it's going to change in 60 seconds, what he's saying.
Quite frankly, what you would do is you would beg forgiveness by the officer, or either you would,
I'm not here to testify what
or
a policeman
either you
will
would
say.
take or either you'd take the code section to municipal court.
Absolutely. Thank you, Mr. Chair.
All right, Mr. Holcomb.
Let's put it this way, you'd win in court.
All right. I actually agree with that point in terms of inoperative probably not being the best word, because that could certainly be interpreted as the light itself not working. I don't right now have a suggestion in terms of how to phrase that better, but I think that that might be something that we'd want to do. But, Mr. Chairman, what I want to ask you is, I think one of your last comments was that if somebody went through the red light after following these rules of waiting for 60 seconds and then they hit somebody, they would be at fault. I don't see that in here.
I think somebody told me it was another part of the code section.
Okay.
Quite frankly, if you're on a motorcycle and you pull out in front of another vehicle,
It's a bad day.
I think that's the least of your worries, trying to figure out that you made a mistake.
Yeah, I don't disagree. In terms of the legal side of it, though, is I don't think that we'd want to have both of them to be potentially in the right under the law, because that could cause some issues in terms of liability if there were lawsuits afterwards in terms of assigning, responsibility.
Do you have any language you'd like to add to this, Mr. Holcomb? Like perhaps nothing pursuant to this shall determine that if you're the cause of an accident.
Do we have any trial lawyers on the committee?
I'm looking at some wordage right now. Not necessarily a trial lawyer, but I've been a prosecutor.
All right.
Thank you, Mr. Chairman. As to the first part of it, it does say if the device is inoperable due to the lightweight design. So it can still be read, it can be operating, but it did not operate properly because of the lightweight. So I think that clears up one issue. And the other, on line 25, it says that you still have his or her right to proceed subject to the rules that are applicable. You have to look both ways. So those other laws would then follow, and that's what would be applicable. Thank you, Mr. Chairman.
And I think if you look on line 24, that if so, that it'll be treated, that light would be treated as a stop sign. Well, you can, if you run a stop sign, you've created a wreck, then you would be held liable.
All right.
Questions?
I don't know, this is the same language that you used, as I say, a few years ago when you got passed through one house and didn't quite make it through the other. And it's pretty important to the motorcyclists that came to me,
All right.
that this be put in.
Ms. Bentley? Frazier, I'm sorry, excuse me.
Chairman, I just have a question about the 60-second rule here. Where did I just
30
read
seconds,
that?
30 seconds.
60-second stop. So motorcycle goes to the traffic light, stops for 60 seconds if the device isn't working. So he waits for 60 seconds, right? And then he can proceed.
If he looks both ways, see nobody coming, and he can proceed.
So if there's other people at the light and he doesn't stay at 60 seconds,
Well, he's in violation of the law if he misses any of these things as stated.
so who determines that though? The other people in the other in the other vehicles that have also stopped, and I'm only asking that in case there is a accident. And so you got all these witnesses. So who is the court going to
Well, it'd
believe?
be like all accidents. The policeman will be responsible for getting as much evidence as he can to proceed and make his case. I think that, I don't know of anybody that hadn't come up to a light like this, and you got. I learned about one a while back, and I was kind of surprised that this person went through a green light, but it was amber light, and he got out in the middle, and somebody hit him, and he was partially responsible because, you should proceed so that you can get all the way through, rather than get out in the middle and somebody hit you. But that had nothing to do with this case.
Thank you.
Steinhauer.
Thank you, Mr. Chairman. With dealing with the issue with inoperative, I could throw this out there and see what you guys think about this. If you change it to say, if a traffic control device or signal has not changed, allowing the motorist to proceed, and then you go into due to the lightweight design of the motorcycle, and that would take the word inoperative out. The traffic light would still be operating properly, but the true issue would be if a traffic control device or signal has not changed, allowing the motorist to proceed due to the lightweight design. That may fix the problem. Just a suggestion as an amendment, possibly.
All right. Would you like to make that in the form in just a few minutes?
Yes, I was leaving it out there for discussion.
Keep that on the tip of your tongue.
You got it.
All right. Have any other questions? Chairman Townsend.
Chairman Yates, I appreciate you bringing this bill, and pretty familiar with it. It was pretty well set up for during the late hours of the night in these small communities that these bikes, when they pull up there and there's no traffic on the road at all, they don't just have to sit there because this signal will not respond to their weight of their vehicle, right? So it wasn't set up for basically traffic flowing today, which anybody ought to have the common judgment not to run on out there anyway on that. But I appreciate that, and at the proper time, Mr. Chairman, I'll make a motion.
Other
All right, if
countries
you'll
have
hold
not.
just a second. Let's see. Is there any other questions from any of the committee members? Then I think this would be the proper time for a motion.
Mr. Chairman, I'd like to make a motion that Bill 869 is passed.
We have a motion. Do we have a second? We have a second. Do we have any other motions?
Friendly motion to amend.
You are recognized for that.
I would ask we amend, take out the word, and in line 22, you'd strike the word is, strike the word inoperative, and in the place of that, you would place has not changed, allowing the motorist to proceed. So the sentence would read on line 22 as, if a traffic control device or signal has not changed, allowing the motorist to proceed, and then you'd go back in with due to the lightweight design of the motorcycle or other motor vehicle.
All right. We'll ask our counsel if that works. So the English is proper in that? Very good. All right. So we have a motion.
I was just
Plan.
going to thank you, Mr. Chairman. I was just going to say, could we just simply use the word fails to change rather than has not changed? Would you have any objection to that? Okay.
Would you rather do that? Would you restate your motion then?
It would read strike is, strike inoperative, and replace that with fails to change, allowing the motorist to proceed. Fails to change that. Let me see if that works. if we did that, I think allowing would need to be changed to prohibiting. Is that,
All right.
Council, would that flow better if you're changing fails to allowing? That really wouldn't prohibit. What you see? What I'm saying, if it's fails to allowing, that really doesn't flow very well. But if you have fails to change prohibiting, that would work better, right? Okay, so let's do it that way. Fails to change prohibiting the motorist to proceed. That would be the change. That's better, I think. Okay.
Does that suit everyone?
Mr. Chairman? No.
All right. Yes, sir. Mr. Atwood.
Representative Hightower, on the make one minor suggestion too. I hate to nitpick this, but I would say thereby prohibiting. Do you need thereby in there, you think? I mean, I haven't written it all down, but it sounded like it. If you would restate it for me, I could help you.
It would be fails to change, thereby prohibiting the motorist to proceed.
Does that help you any?
You could do
Okay.
that. Fails to change, thereby prohibiting the motorist to proceed.
Due to the lightweight design. Yeah,
Yes.
I like that better.
Is that satisfactory?
That's fine.
All right. I'll ask Julius again. Does that work now? Very good. All right. So we have a motion. Do we have any other subsequent motions to amend? Is everybody satisfied with the 60 seconds? Very good. Very good. We have a motion. Yes, Julius.
Yes, I didn't pick up on that. Yes, we could do that. You're changing motorist to driver to make it consistent with the rest of the bill. Yeah. Thank you for that.
All right. Committee members understand the changes now, the amendments? All right, we have a motion, a second. We have a amendment that's been introduced. Do we have a second to the amendment? Second. All in favor of the amendment, say aye. Aye. Opposed? We're back to the initial status of the bill. We have a motion, we have a second of this bill as House Bill 869 as a committee substitute. All in favor say aye. Aye. Opposed? And ayes clearly have it. Thank you, Mr. Chairman.
Thank you. You know, the rest of the world don't look on these mechanical devices the way we do. I was in Venezuela on a trip, and the guy looked both ways and went through 60 miles an hour. And over in World War II in Paris, the guy would beep, beep, and going through.
They drive by the horn in certain parts of the world.
Good day. Thank you, Mr. Chairman.
There might have been wine involved back there.
Out of respect for another chairman, we have Chairman Wilkinson, House Bill 841.
Thank you,
Right
Mr. Chairman, members of the committee. This is House Bill 841, working off LC 390506. As you all know, I spent my career at the Coca-Cola Company, and the late Ike Herbert, who was head of worldwide marketing, said as we would be preparing a new ad campaign or slogan or whatever, he said the hardest thing is to pick up a pencil and look at a blank sheet of paper, but start. And this is what the chairman suggested I do, that because I'm certainly not an expert on this, but it's a public safety issue, and the chairman said that at least start it, and hopefully the committee could help us through it to help our citizens. You know, I've been very fortunate. I've gotten to go to air shows all over the world, and as you know, air shows draw hundreds of thousands of people. And I supported the Blue Angels in my 26 years in the Navy on a number of occasions. And actually, I was offered the public affairs job with the Blue Angels. And selling flavored sugared water and promoting Coke, I was like, well, you all get all the people you want. And they said, that's not the problem. It's the collateral damage we do. You have 100,000 people a day, but you have 200,000 surrounding the area. And there is the situation, public safety, parking, traffic, emergency vehicles. This past fall, I was up in Rome, Georgia for the Wings Over North Georgia Air Show, which is a great air show. I recommend you go to it next year. A friend of mine drove, so I was able to observe a good bit. And the folks who did not come into the airport area were parking their cars in neighborhoods so they could get a view of the flights and so forth. And I looked, and I said, what would happen? What would happen if someone had a heart attack, fire in the house, or whatever, if that's a blocked area? And in Representative Atwood's district, and I've got you photos of that, I've seen it time and time again. What I'm saying is, if there is an access for an emergency vehicle, fine. But if there is not, how do we protect the homeowner? How do we make certain that an emergency vehicle can get to his or her property? Now, on these particular photographs, county maintained roads, so you've got the 30 feet on each side right away. I have no problem with that. All I'm saying is, if you can't get a vehicle through there, then how do we protect the homeowner? Do we allow them to put up signs? Do we allow them to have X feet? I don't know what that distance would be so that an ambulance or a police officer or fire truck could get in. So I'm hoping we can find a way to protect homeowners. That's the purpose of this.
Very good. All right, ladies and gentlemen of the committee, any questions on this? Mr. Talbot.
Mr. Chairman, are you talking about parking on the right-of-way of the streets?
I have no problem with that, and that's law. But what I'm saying is, if there's no discernible entrance to the home, and if you'll notice, Mr. Chairman, it has where it states what the driveway looks like. It's clearly identifiable by pavement, gravel, or other permanent markings. So if it's clear, then you can't park there anyway.
Yes, sir.
So that's covered. But what's happened, as you can see in these photographs, you have a number of places where an emergency vehicle is not going to be able to get through.
So otherwise, it's either on city or county property or a private homeowner's property.
Well, the fact of the matter is that at 30 feet from the center of the road into the yard, that belongs to the county or the city or whatever.
So what about city or county ordinance?
I'm sorry?
City or county ordinance?
That is something that they have looked to us to make it a statewide situation where they could go back, yeah, the ones I've spoken with.
Okay, so they want to let the state
the state that, yes, sir, I mean, this, for example, on this particular street, these streets, it would not have to defer to Representative Atwood, but it would probably apply to maybe probably 25%. The others have some sort of access. But the ones that don't, and people pull up and they block it. And these are during large events, as I noted in Air Show, for example. These photos were taken on the 4th of July. And I wish I'd had photos from Georgia, Florida weekend, but some of those I would not be able to show.
Thank you, sir.
Yes, sir. Thank you.
All right, any questions from the committee? Sir, good.
Thank you, Mr. Chairman. Mr. Chairman, just briefly, are there a lot of examples of homeowners not being able to receive emergency care, whether it be EMS or fire protection and things of that nature?
The possibilities, yes, sir.
But more specifically, are there any like real world examples now to where that has happened?
During Georgia, Florida weekend, yes.
Okay,
there were.
just this past. Okay,
Yeah,
all right.
ambulances. Yeah.
Thank you, sir.
And actually, one police officer, maybe two. By the way, there were some situations there where people had rented homes, and the contract said 4 people, and within 30 minutes there were 75 people, and they were evicted. So, but yeah, but it's the possibility too. I don't want to run the risk. I don't want to run the risk if we can. But I think it's up to the homeowner too. It's not up to the county, not up to the city to go market. If the homeowner has a clear definition, and law enforcement has a clear definition, they should be able to do it. If they don't want to do it, that's it's their personal responsibility, in my opinion.
Ms. Frazier.
Yes, sir. Thank you. Chairman Wilkerson, what are the ramifications for if someone does park in my driveway? Can I just pick up the phone and call the police? And say,
You
look,
can that on a driveway,
I can do
yes.
that already.
Yes, ma'am.
So, so what's the penalties for this in a big event?
I think it's done by each jurisdiction.
So the police will ticket them, or
Yes.
have the vehicle move?
Well, it depends on the
circumstance.
Well, it depends too on the enforcement in the particular jurisdiction. For example, if someone pulled up and blocked a driveway, I mean they can be towed right now. The owner can do it. What we're saying is, if there is no driveway, then many of these homes you have to access from an alley, and you cannot. There is no driveway to the front, or basically it just comes up the back.
So the purpose of this bill is just for emergency purposes, for the.
If a homeowner is concerned that an emergency vehicle could not get to their property, they should be able to have the right to mark whatever amount of distance you all come up with, to say this, there's no parking here. This is for
Okay, so this is for signage.
Well, that's what I would recommend to a homeowner. Again, the chairman suggested I throw this out and look for you all to help me craft it.
Okay.
So I'm very open to
Thank you.
any suggestion.
All right.
Yeah, and it could. I would recommend putting up signs.
Thank you, Mr. Chairman. I can see the need where we need to do some of these. It's going to involve city and county jurisdictions because they're county roads and city maintained, and we do need some regularity to it. But it might be wise if, Mr. Chairman, we could have some folks get together and work on this bill.
Which I would welcome, but I would remind you, this is under Georgia Code 40.
Okay.
So this is state.
It is state. We can
It is
have the
state.
authority to do it. Then I do think we need to have a committee or a subcommittee, somebody work on this bill to fine-tune it a little bit.
No, I would welcome that. As I said, that was the chairman's suggestion,
Thank you.
that I pick up that blank sheet of paper and start this process. But again, it reminds me of the, Mr. Chairman, when we did the meningococcal meningitis vaccinations for college students about 12 years ago or so. We'll never know how many people we saved. It's one of those things. But it is a preventive action. And in this case, we probably will be able to have statistics. But again, it's up to the homeowner to act. It's not up to us to come up with anything, but to give them the opportunity for more protection.
Okay, good. If I mind at the discretion of the chair, I think we need to do a little bit of work of definition on this, as you and I had spoke about earlier. And if the author would work with some of the members, I'm going to ask Representative Green if he might lead a working committee on this. Representative Frazier, would you like to be a part of this? Representative Cook, if you don't mind. And would y'all mind working with the author of this bill and see if we can develop some language and get it back to the committee, if you could, by no later than maybe Monday for next Tuesday's meeting? Y'all could.
Mr. Chairman, thank you. This is exactly what we were hoping to start this process, and with people who are experts in public safety. So thank you.
Thank you, Mr. Chairman. A real gentleman there, folks.
Thank you.
All right. Mr. Dickey. Committee members, Mr. Dickey was very diligent. He was here last Tuesday with some of the members as we had struggled in the ice storm, and we saved a lot of people a lot of time being stuck on the interstate by having a meeting last week. He presented this bill last week, and for some reason we're back again with a substitute if he's sure he wants to proceed with a substitute.
We do.
Just for the benefit of the other members who weren't here, could you just briefly, and brevity is of a value.
Okay. Thank you, Mr. Chairman. If you look down to line 26, it's presently a misdemeanor to discharge a firearm within 50 yards of a public highway, really for any reason. And we are doing four exceptions for that. And if you'll see on line 31, the first exception would be an indoor-outdoor shooting range. Many I've got a shooting range in my district that is within that 50-yard distance, and just worried about maybe future problems with law enforcement enforcing the 50 yards. We would also, on line 32, exempt firearm safety courses. I also have public safety training center in Forsyth and some of those across our state. We also retail operations for repairing guns or selling guns has an indoor range, a qualified range in their retail operation, but most all of those also within 50 yards of a public highway. And down also we will exempt legal hunting, which occurs within 50 yards of the highway. And the substitute bill here, we went back and added, GMA was concerned about possibility of legal hunting within a municipality of the state. So we added that language there, Mr. Chairman, on line 39. Those are exceptions that I'm proposing in this bill to the 50 yards. I also, Mr. Chairman, if you had time, DNR is here. Colonel Jeff Weaver with DNR, I know with some concerns about the hunting part of this bill, and if you would like to hear his take, DNR's take on the hunting part of it, he's certainly willing to come up here. But I think we've taken care of GMA's concerns with this bill.
I knew we should have went ahead and handled this out last Tuesday, but Colonel, you want to come on up? And I'm sure because of the substitute, is anybody here from GMA? Yes. All right. You come on up here and stand in the wings in case we want to hear from you.
Thank you, Mr. Chairman. Representative Dickey did reach out to us prior to this bill being dropped and ask our opinion, and we were totally fine with it. Actually, it syncs up our Title 27, which is our main game and fish laws, that we go by for hunting from a public road. We have no yardage in our state code there. So, for instance, we run across this a lot on dove fields, where you got a county road running through a field, and you got dove hunters backed up on each side, and they're certainly within 50 yards. But they're acting safely, they're properly equipped, they have permission, and we allow that. So,
You like the bill?
yes, sir, I'm good
Do
with
you
it.
like the substitute?
I'm not familiar with the substitute.
Representative, would you like to show him that one little minor change y'all made for the benefit of GMA?
Except not within incorporated municipality of the state.
Yes, we're good with that.
Good to go with that?
Yes, sir.
Senor Rishi, are you good to go with that? You like that? Y'all stand right there. Committee members, anybody got a question they want to ask before any of these folks get away? Brevity sort of went out the door.
I was going to make a motion.
Any questions from the committee? Vice Chairman Taylor.
I would like to move do pass
As a committee substitute.
as a committee substitute.
And that substitute would be LC 295869S. All right, we have a motion. Did I hear a second? We have a motion and we have a second. Any subsequent motions? Any questions from any of the committee members? If not, all in favor say aye. Ayes clearly have it. You're on to rules, brother.
Mr. Chairman, members of the committee.
Thank y'all. Ladies and gentlemen of the committee, we do have a, everybody has signed up for this one. All righty. We have in front of you House Bill 837. Representative Hamilton, Chairman Hamilton, I'm sorry. And we'll be addressing this from the substitute.
Correct.
You have a substitute LC 287016S.
That's correct, Mr. Chairman. Mr. Chairman and ladies and gentlemen of the committee, I bring before you House Bill 837, and for the purpose of brevity, let me give you a quick history lesson, and I'm going to say it in just a couple sentences. In 1992, the state of Georgia decided that it wanted to get out of the misdemeanor probation business and left as an option that probation could be done at the county and municipal level, both by private or public. And then in the year 2000, they mandated no more. And so right now, under law, the misdemeanor probation is handled at the county and municipal level, at the local jurisdiction level, and they have the option of doing it either in-house publicly, or if they want to contract with a private firm, they can do that. There was recently some court decisions that impacted our ability in the state of Georgia to toll a sentence. Now, when I first got involved in this, the only toll I knew was the toll we took down on Georgia 400 over here, where I threw a couple quarters in. So I've become a very quick, I stayed at the Holiday Inn Express, so I'm now a lawyer. Basically what it does is tolling gives under a misdemeanor probation, when a sentence is tolled, they basically stop the clock. And so when you sentence someone to misdemeanor probation, you have to follow the terms of those probation, and if not, there's provisions if they abscond and leave the state, they can't find them, then they can take this order to the judge, and the judge, after due diligence, determines that that person is nowhere to be found, and they issue a tolling order, which stops the clock, which all that means is the person's time from that point on does not continue, so they don't get credit for probation beyond that. Well, effective this past year, tolling is illegal in the state of Georgia. Basically, we don't have the ability to toll misdemeanor sentences in the state of Georgia based on some interpretation of the law. So let me explain something to you here first. This bill does one thing and one thing only. It addresses that. It gives the power back where it needs to be. You will have people that will try to make this a private probation bill. It has nothing to do with separating out private probation. I tell people, if you don't like private probation, drop a bill. introduced legislation. The state of Georgia made the decision many years ago to get out of this business. So this bill right here simply fixes something that has been in law for 22 years. Let me give you some numbers. Right now, today, we estimate that there's 321,618 people in Georgia, Georgia citizens, that are on misdemeanor probation. 321,000 people that if they decide to leave, their probated sentence continues. There's nothing we can do about it. So we've lost the teeth that we have to be able to have in probation. In 2011, the Department of Corrections estimated that it cost about $1.33 per day to monitor probationers. If you take that same 321,000, that would be a cost in 2011 of a minimum of $156 million to the state of Georgia that we would need if we wanted to get back into that business. Interestingly enough, in $2013 dollars, if you take those same 320,000 people that are on misdemeanor probation, those probation entities have only brought in $119 million. So we've already saved over $40 million, or roughly $40 million in that. That doesn't include the almost $12 million that we've collected on top of the probation fee. There's a $9 fee that goes into the Crime Victims Emergency Fund. So there's another $12 million that's not being counted. Plus, that number does not count the 4.3 million hours of community service that these people on probation are doing on an annual basis. By the way, when they do that 4.3 million hours of community service in the state of Georgia, they are supervised by probation officers. And so many of those community service dollars are, guess what? They're done in lieu of fines and penalties and other things. So this idea that we're not being compassionate with these people. Let me also make sure that you understand what probation is all about. You either are convicted of a crime or you plead guilty or plead for that crime. It's not just made up. You're convicted or you plead. You also have the ability to agree to that probation. So this idea that we're running around putting all these people in jail or probation, it's because these people have actually broken the law and there are consequences to those actions that those people have taken. Let me also tell you a little bit about the oversight. I've heard people talk about there's not oversight. There's an organization called SIMPAC. SIMPAC basically is the County Municipal Probation Advisory Council. This council is set up. It's got a standing or sitting judge from every branch. It also has several other members on there. And this group sets up the rules. And so it makes no difference whether you become a private probation officer or a public probation officer. You still have to adhere to the rules that SIMPAC has stated. They also have sanction abilities. And so, matter of fact, there are examples in recent history where SIMPAC has stepped in and has sanctioned both private as well as public probation entities for violations of the rules of SIMPAC and or the violations of law that we have in this great state. So when you hear these things that there's no oversight, is completely false. There is. And ultimately, they have to have bonding, insurance, indemnification, background checks, training, staff development, records maintenance. Have to do many of these things. And for the purpose of brevity, let me say, I have worked very closely with the various courts in this great state. We've worked with the municipal courts, the state courts, the superior courts, who are not very much affected because they deal mainly in felony. They've seen this. They're not here to speak on the bill, but they've had their involvement. And so I will tell you, we've got people from the Prosecuting Attorneys Council. We have members of all of those groups here in the audience today, and for the sake of brevity, they're all prepared to come up here and tell you that you ought to pass this bill, because if we don't, we have a real problem with our court system across Georgia because we don't have the ability to toll these sentences. But I would prefer to say they're here, they can recognize themselves if you want to, or if we have questions of the members that would like to talk to them, be happy to do that. And with that, Mr. Chairman, I'll be happy to yield any questions or have any of the learned colleagues out here in the audience answer questions. Thank you.
Thank you, Mr. Chairman. And we do have some people that are signed up to give testimony. But before we start that, is there any of the members of the committee that wishes to ask any questions of the chairman on this bill? Yeah, I see some. Mr. Holcomb.
Thank you, Mr. Chairman. I have a few questions. One is, what type of offenses are we talking about that would be subject to this type of probation?
These are all misdemeanors. Misdemeanors.
Traffic
only.
offenses.
Anything that is classified as a misdemeanor. Okay. If the judge decides for whatever reason that probation is an option, I failed to make a very important part. Anything. Let me make sure that this is very, very clear. I'm sorry I didn't do this. Every single power that a probation officer has or exercises is granted by the respective court and or judge. A probation officer that does anything outside what the court order is in violation. They can't do that. A silly example was given to me about what happens to that person that goes out and tackles a person, wraps him up in barbed wire, throws him in the back of a truck to take him in because he's arrested him. Well, probably going to be prosecuted because you can't do that. No judge gives that person. First of all, none of these probation officers have arrest power. They can't do that. So there's a lot of misinformation out there. But anyway, I know that's not your question, but I want to make clear that any power that a probation officer has is because the court has granted, including whatever the fee is. If they assign a fee that they want that probationer to pay, guess who decides that? The court, the judge. If they want them to wear electronic monitoring, guess who decides that? The court. So the court is the one that's using this as a tool to monitor and assess where these people are that are on probation.
With respect to the electronic monitoring, prior to this bill, because I see it's in the underlined section right, indicating that it's new, particularly lines 171 to 177, prior to today, was electronic monitoring for misdemeanor probation available?
Yes, great question. Matter of fact, the reason for this being new, this is not new code. This is simply moved to a new because in the interpretation of the law, there was a word called not, and what the determination was that they looked at the word not, and there was a bunch of things decided. We think the state's intention back when they put that in there was a completely different reason. Those were administrative. So we simply took the code that was in this other section, brought it over here, as well as the tolling part, which starts on line 206, and made sure that is in there. So we just wanted to be clear that probation officers do have the ability to do this in state law.
And this has been the case previously as well? Correct.
This, for 22 years, this has been going on. So we simply took the code that was already there, brought it to this section to make sure that it's recognized as they do have this authority, this power.
And I'm familiar with this section, so forgive me for not knowing it. My final question is lines 134 and 135. I certainly understand the intent, but it seems potentially pretty broad, too, that the probationer shall avoid injurious and vicious habits and avoid persons or places of disreputable or harmful character. 134 and 135? Is it a different version? Yeah, do I not have the current version?
You have LC 7016S.
I have 286949.
No, that's before the sub.
Substitute.
I've been given the wrong version.
Here you go.
That wasn't helpful. Okay. I've got the old version as well. You need one too? He needs one too. You got an extra one on? No, I have one. I'm sorry.
Anybody else need one?
I think we all have one.
It's still there. It's different lines. 146 and 147. Are these defined anywhere, or do you know how these are? I understand the purpose and the intent, but they jump out at me as potentially being kind of broad.
that is language that is already in code, so I can't speak to the fact of maybe someone else can, but that's code from another section that we brought over. In other words, that's already in code that they were using.
Applying. Okay.
Right.
Thank you.
It's new. It has underlining that we brought it, but we copied it from another section and brought it there. Thank you.
Representative Jackson.
Thank you, Mr. Chairman.
Valued committee member and former probation officer.
Probation officer, yes, sir. Thank you, Mr. Chairman. Representative Hamilton.
Go easy on me now.
I'm trying to clarify something. What we're doing here is simply talking about probationers who have absconded and cannot be found, and the time is running, so we're asking that the judge has the power to toll these warrants so that the fines and restitution can be collected.
That's correct.
And under normal circumstances, you get in these misdemeanor cases and they can wear you out. I know as I work misdemeanor cases from state court about 2 or 3 years, and it's like a revolving door. But what I want to make sure is that before we're asking the judge to toll a warrant to sign the non-S, that we've exhausted every effort available. The sheriff department has looked for them. We've looked for them in the field, and we made sure that this person has absconded. He's either moved from the resident that he's given us in the beginning, and he cannot be found before we ask for a non-S to be signed.
Right. And if you look at lines, I appreciate the question, lines 206 through 217, they're both conditions of the filing of tolling. So you can see a affidavit, which an affidavit is if someone willfully violates an affidavit, that's a false swearing. I mean, it's prosecutable. So the person has to do that, or the other is talk about basically when they've absconded. That's right.
One more question, if I may, Mr. Chairman.
Yes, sir.
We're not saying that this person has to pay any additional fines.
No.
Only the fines that were imposed at the beginning of the sentence from the sentencing judge.
That's
We're not
exactly
adding
right.
anything else onto the fines.
That's right. And the judge, it's very important to understand, the judge has a discretion, and there's people in this room that would be happy to tell you many stances where the person doesn't have the money, maybe they're indigent, whatever, and the judge has the power to say, you no longer have to pay those fines, you no longer have to pay those fees, and we've got probation officers, both private and public, that still spend time with people on probation on a regular basis, even though they're not collecting any fee because the court has said they don't have the money to pay that fee.
Thank you.
Thank you.
That's the reason I love this committee. We have such a varied amount of experience on this, from former DEA to state troopers to parole officers, probation officers, and actually a few attorneys. Now, I'm going to have to make an apology to everybody here. This room was only reserved for 1 hour, and the word brevity really didn't mean a whole lot to some folks.
It did to me, Mr. Chairman.
But I do want to tell you something. You're not getting off the hook. We're going to have to vacate this room because there's another committee coming in here for meeting. But if everybody would just take their phones, take them off, make their calls, we're going to reconvene in 6:06. We call this meeting back to order. All right, Mr. Chairman, you're in your rightful place. We were having some questions first before we went to testimony. Are you number 12? Ms. Frazier.
Thank you, Mr. Chairman. I just pushed my button. I can't wait to talk to my classmate here. Okay, Representative Hamilton, excuse me, Chairman Hamilton, under...
I'm sorry, what line?
Line 22.
22.
It said the General Assembly did not intend to restrict the powers of judges to impose, suspend, toll, or revoke, otherwise manage the probation of misdemeanor and city, county, and city ordinance offenders.
Right.
They did not intend.
Right.
Then on line number 30, this act is being enacted in response to the decision of the Supreme Court of Richmond County in a series of cases in which the court found limitations on the use of such probation officers by courts that the General Assembly did not intend to exist.
That's correct.
So, is this legislation being prepared because of the decision made by my judge in Richmond County? But it is not, it is the General Assembly's intent, did not intend to restrict the powers of judges. So are you saying that the judges cannot, any judge in 159 counties cannot make a decision on whether they want to suspend tolling, revoke, or otherwise manage their probation system?
To my classmate, lines 11 through 35 are what we call findings. And it's just a clarification of intent. It has no weight of law. It's an expression of the intention that's going on here. And so we would not be standing here today if a particular lawsuit had not moved forward. And so we, as a General Assembly, based on that lawsuit, we want to make sure that we not only fix it so that that lawsuit is not applicable anymore in the future law for the misdemeanor probation, and we thought it was a great opportunity to say that we didn't say back in 1992 what the intention of this is, because the intention of this legislation, or this section right here, is to say that we don't want to have misdemeanor probation handled by the state of Georgia, and we want to delegate it to our local jurisdictions for them to find out or to do. However, we just want to clarify that intention. That's the only purpose of that. But it does not have any bearing on law. It's just the intentions of the General Assembly.
Okay. Yeah.
Yes, sir. Happy to. Very briefly, though. My name is Wes Taylor. I'm a state court judge in Fulton County. Have been for the last 3 years. Before that, I did a number of things, including I was an assistant solicitor in DeKalb County for a while. I wanted to thank Representative Hamilton for all his work on this bill. He has put in, I know, a lot of work on that. I also want to thank members of the committee and Chairman Powell. My brief statement is the Council of State Court Judges supports the bill, and we hope that you do pass this out. If you have any questions, I'm happy to answer them. I do handle all misdemeanor probation, so happy to answer any questions you may have.
It's nice to see a jurist that knows what brevity means. Do we have any questions of anyone from any of the committee members of the judge? Thank you for being here.
Thank you.
Judge Charles Barrett. Judge Barrett.
Good afternoon, Mr. Chairman, ladies and gentlemen. My name is Charles Barrett. I am the Chief Judge of the municipal courts of the cities of Duluth, Lilburn, Berkeley Lake, Peachtree Corners, and an associate judge with the city of Sugar Hill, all in Gwinnett County. I'm here today on behalf of the Council of Municipal Court Judges, and I am also a past president of that organization. We thank Representative Hamilton very much for all of his efforts in developing this bill. I am here to briefly advocate for the bill and tell you, members of the committee, that our council is in favor of the bill, fully supports it, and asks for its approval.
Very good.
Thank you, sir.
Any questions from any of the committee members? Judge, how many towns do you, how many municipalities do you hold court in?
It's a total of 5, Mr. Chairman.
5? You would have took a Supreme Court appointment if you couldn't afford the pay cut, correct?
I'm not sure about that, Mr. Chairman.
Well, we thank you for being here.
Thank you, Mr. Chairman.
Thank you for your time. We have Sarah Garrity, if you might.
Good afternoon, Mr. Chairman, members of the committee. I'm Sarah Garrity from the Law Office of the Southern Center for Human Rights in Atlanta. Our perspective on this bill comes from having represented indigent people placed on probation for misdemeanors with private companies, and we have some concerns about the bill that we'd like to share with the committee. If I may tell you about one of our clients who was placed on private probation with a company in Augusta. Marietta Connor was convicted of, pled guilty to failing to yield to a pedestrian at a crosswalk. She was placed on probation because she didn't have the $140 of the fine to pay that day. If she had had the $140 to pay, she wouldn't have been on probation at all. But because she didn't have $140, she was placed on probation with a company and required to pay $39 per month as she paid off her fine. She made 5 payments totaling $185.99, but because she couldn't pay in full each month, the amount that she originally owed, $140, doubled to $305. We met Ms. Connor in court when she was having difficulty paying and was facing incarceration for her inability to pay. She was someone on a limited income. She was an older lady who survived on her Social Security benefits. And eventually we intervened and the court terminated her probation, but her experience is illustrative of many people who are indigent and who are on probation with private companies. We have a couple of concerns in particular, one with the electronic monitoring provision in the bill under consideration today. The bill would sanction a significant expansion of electronic monitoring as a condition of probation in the misdemeanor and traffic context. It would give the courts power to order electronic monitoring for any offense, even offenses like Ms. Connor's failing to yield to a pedestrian in the crosswalk, driving without a license, improper lane change, and all of those. This bill gives private companies the opportunity to make a great deal of money off of electronic monitoring. Electronic monitoring is expensive. In some jurisdictions, it's $6 a day for regular monitoring, $12 a day for electronic monitoring of alcohol consumption. Keep in mind that these are misdemeanor cases, traffic cases in some instances. The maximum fine for these cases is $1,000. But when you add in the cost of electronic monitoring, you're talking about an extra $2,100 a year to, in some cases, $4,300 a year for electronic monitoring. So the bill as written authorizes private companies to collect fees for electronic monitoring, but there's no limit on the amount of the fees. And it doesn't limit the kinds of offenses for which electronic monitoring is appropriate. Second, with respect to the tolling provision. Our concerns are twofold. First of all, the Georgia Code already has a code provision that deals with the probationer who is not doing what he or she is supposed to do on probation. Let's say he doesn't pay, he doesn't report. The Georgia Code section 42.8.100 permits a judge to revoke that person's probation if he's not doing what he should do on probation. In addition, we've seen tolling allows the extension of probation for minor crimes so that individuals find themselves still on probation years and sometimes, in a few instances, decades later. We heard a little bit about Judge Craig's order that prompted the bill in this case. Judge Craig, of course, a respected jurist and a former district attorney, made findings of fact in that order about some of the problems that arise when tolling is permitted in traffic and misdemeanor cases. In particular, he talked about the procedural problem of probationers being arrested and jailed years after their offense. And I'll just briefly wrap up by saying this. What often happens is that the private probation company will seek a warrant for a probationer it says has violated probation for not paying. It gets a judge's approval, but no action is then made to find the alleged violator or bring him into court, speaking to Representative Jackson's question earlier. The person may not even know that he has a warrant. Years can pass, and then one day that person encounters a law enforcement officer, and he or she is whisked off to jail, often on a non-bondable warrant. This happened in Augusta. Gary Allen, 82, an Alzheimer's patient, arrested on an 11-year-old probation warrant. The underlying charge was criminal trespass. And as Judge Craig wrote in his order, this practice offends basic notions of due process by depriving the probationer of the opportunity to defend the alleged violations of probation in a timely manner when evidence may be more readily available. It also subjects the probationer to incarceration after the sentence has long since passed. Those are the concerns we have, unless the committee has any questions. Thank you for your consideration.
Thank you. If I might ask a question.
Yes, sir.
I want to go over a couple of your points that you made. The elderly violator.
Yes, sir.
That received a $140 fine. Could the judge not have waived that or made other accommodations, being with the power of the bench, knowing that she was destitute?
Your Honor, excuse me, I'm used to being in court, Mr. Chairman. Of course, judges do have the power to mitigate some of the harms that we find in our practice. The reality is that you've got a courtroom full of people, a packed courtroom every day of the year, and mistakes like this happen. And our concern is that this bill expands pretty exponentially the power of private probation companies to make money often off the backs of those least afford to pay.
Well, since you've said it that way, let me carry it to extend that my question. So do you actually have a problem with a company making money? The reason I'm asking this, there's only two people on this committee that were here when this bill was originally passed.
Yes, sir.
Representative Green and myself. And we had reached a point in this state, and the history behind this was that, quite frankly, we couldn't afford to continue to use state employees under Department of Corrections at probation to basically look after misdemeanor offenses and felony offenses.
Mm-hmm.
And, you know, of course, the people that went out at that time, they set up a multitude of private probation companies around the state, basically to carry out the orders of the courts.
Right.
They're not carrying out those orders of theirs, they're carrying out the orders that is issued by a judge, and I believe that's the proper way of describing this. Judge, nod your head if you think I'm right, and if I'm not, be sure to tell me. But so these people are paid, they've got employees and they have to pay them. So it's like the elderly lady, that's, you know, quite clearly that's a bad situation.
Yes, sir.
If somebody had stood up, such as the Southern Center had been there to help this old lady, or someone else, and had maybe described it to the judge that this lady's destitute, could there be some other remedy to that? Then the private probation firm would never have, am I on the right track? If that had happened, then that private probation firm would never have never had to handle this case to start with.
Well, Your Honor, or excuse me again, Mr. Chairman, I mean, to the extent that you're asking whether, you know, we have a philosophical opposition to privatization in general, I mean, I don't think we need to get there for purposes of this bill. I think our main point is that the companies do have a financial incentive to keep people on probation, and it behooves us all to be extra vigilant in instances in which there's an opportunity for the companies to expand their power, and this is what this bill does. I do understand that in many jurisdictions throughout Georgia, as it happens now or before Judge Craig's order, that private companies do have electronic monitoring contracts, but I do want to make clear that Judge Craig's order did find that there was no authority within Georgia law for the private companies to do electronic monitoring, and there was no authority for courts in state courts using those companies to toll private probation sentences.
My second part of my question was dealing with your comments about electronic monitoring. You know, if it is, and if I understand right, these private probation firms, they can only do what the court has allowed them in the terms of the sentencing. Is that correct?
I think
they can't. I guess what I'm saying is, they can't just go out there and put an electronic monitoring device on an offender unless the court has ordered such.
You're right about that, Your Honor. There has to be a judge's approval for an electronic monitoring order. I guess our point would be, why give judges the ability to put someone who's charged with, or excuse me, who pleads guilty to improper lane change on an electronic monitor. There are circumstances where electronic monitoring may be the absolute right thing to do. Our concern is that people who are convicted, by and large convicted of misdemeanor offenses, traffic offenses, those aren't people who need to be electronically monitored.
So possibly what we need to do is that maybe the judges need to look at a little bit more, and legislators about the power given to judges in dealing with these instead of trying to put it all off on private probation firms.
I think the legislature has the power to impose reasonable limits on when such orders are appropriate. I'd also add, with respect to the tolling provision, that one consideration may be to put a limit on the time after which, it would no longer be appropriate to seek fees on a probation sentence.
And then that brings it to my third. You brought up my third point on
Yes,
the
sir.
tolling. If I understand, and someone who is a non-attorney, if I understand it, and quite frankly, the folks like the $140 fine and such, but also misdemeanors are like DUIs.
Yes, yes.
And a DUI, last time I checked, I think a DUI offense, the first offense ranged from $450 to $1,000 is the fine. And quite frankly, I think in reality we all know that you don't go to a private probation, you're not remanded to a private probation service if you can pay your fine. It's really about getting that money collected, and that's the one thing that keeps the system, actually makes the system work. So with tolling, if I understand correct, if we do not make provisions for the tolling, that if a person was, me or anyone else was a DUI offender,
Mm-hmm.
and say we went and disappeared,
Mm-hmm.
we appeared in court, we were remanded to a private service, and if I just said I don't have the money, I'm not going to deal with this stuff, and I disappeared, and I disappeared for that 12 months. If you don't have tolling, then you reappear to 12 after the 12 months, and you don't have to pay the fine, you're out from under it. At that point, all you do is you just go to the DUI school, do the assessment, go to DUI school, and get your license back. Does that seem quite right in how we administer justice?
Well, I see your point, Mr. Chairman. I guess two things in response to that. First, I would contend that the first appropriate thing to do in that case would be during the term of probation, if there's evidence that the person is not doing what he should, not reporting, not paying, whatever it is, that there's a code provision that in the law as it stands right now that permits a judge to haul that person into court and deal with it there and potentially revoke that person's probation if the facts allow it. Or, as an alternative, we contend that there could be a tolling provision, but that there should be limits on that provision. For example, we shouldn't have a situation where you have a warrant that is issued in 2005, a warrant that's never served on the person may or may not know about, and then 10 years later you have that person arrested. It's just not the kind. That may be appropriate in a case that is a felony case, for example, but we don't have the same considerations, public safety considerations, that apply quite in the same way with someone who has a misdemeanor conviction.
Thank you. We have some other questions. Representative Atwood.
I'll pass, Mr. Chairman. My question was already answered.
All right. Who's number 13? Ms. Waits?
I have a question. It would appear to me, Mr. Chairman, that if we did not limit the fees or fines, that it could potentially provide an incentive to the potential companies. So my question is, would it be appropriate in this particular legislation to place a limit upon the fees and fines and limit them to what the judge in fact imposed? which would address the issue of the backlog, I would think.
Are you asking me my opinion on that?
Yes, sir, I am.
I don't think that would be appropriate about changing the structure of the fine structure of the judges in this bill. This bill is basically to cure the problem of how private probation is operating. Okay. If the subject matter about changing, if you want to see the judges, if you want to limit the amount, or if you want to say that if you have a destitute citizen and they've done a jaywalking offense, and that $140 is just crazy to put someone like that, then draft you some language that would say that the judge clearly states maybe the judge needs to use a little bit more common sense and human compassion. Maybe. I'm not sure, but I don't think this would be the bill to do that in. Okay. I would also think that, there's a lot of things that need to be looked at, and I certainly can appreciate the Southern Center, the witness, her compassion. But I have some concerns that while, quite frankly, the laws aren't always right, nor are they just in how they're meted out. But if you don't have a system that works, you will have a collapse of the justice system. So if I'm fined and I go to court and I have been found adjudicated guilty, and if I don't pay what I'm supposed to pay, either pay it up front or either go through the private probation services, then I haven't paid society back. So if with the current doing away with the tolling, so if I disappear for ever how long a period of time, then that's justice hasn't been served. Now, in the case of the guy that had Alzheimer's, I don't know how long he had Alzheimer's. I don't know if he had Alzheimer's or dementia and disappeared and just didn't pay and all that. But that's something that the judge needed to work on down there and not worry about this person not reporting to pay his dues. But he needs to deal with that. If the guy certainly had mental conditions, Alzheimer's, dementia, then so be it. Let the judge deal with that. But we're dealing with another issue, and that's the administration of a process. And unless we're prepared to do away with all misdemeanors, I quite frankly think we're up against and I'd like to see, if you'd like to go in there and revamp the structure of fines, I'd love to add into it, because quite frankly, we've got a whole lot of surcharges on these fines that need to be abolished.
Yeah, I certainly support the measure today, Mr. Chairman. But again, my concern is it's taking a fine of $150 and it doubles through this particular provision is all my concern is today.
Well, it's regretful that somebody can't pay that fine. So, and that's the only way in our society, unfortunately, the reason that we've always had probation servers, and it was the State Department of Corrections before it was private probationers, quite frankly, they were there to be sure that people paid their fines. Because if they're not paying the fines, then the orders of the judge aren't worth a snuff. All right, questions? Any other questions for the witness? Mac.
Thank you, Mr. Chairman. I have a question for you. I didn't get your name.
Sarah Garrity.
Ms. Sarah. You said one of the options would be to, if a person have absconded, then the option would be for the judge just to haul him into court and revoke his probation. Well, isn't that the whole thing that we're talking about, is that person can't be hauled into court because you've tried to find him, you've exhausted all your resources, you've even issued a warrant. The sheriff department can't even find him. Or at the known address, he can't be found there. Friends, nobody can tell you where he is. So he's considered as absconded. So you can't revoke a probationer when you can't find him.
Yeah, I think that the practical problem that has arisen in some jurisdictions, Augusta in particular, is that there's sort of a missing step. There's the warrant is signed by the probation, the affidavit is sworn out by the probation officer. The judge may sign the warrant, but then, and so there's an active warrant out there for the person. But then the next step is not taken. There's no effort to bring that person in back before the tribunal to
But
answer.
isn't the warrant the effort? When a judge signs a warrant, that's the effort.
Not necessarily, sir, because I think what sometimes happens is that the probation officer simply says, this person hasn't paid, this person hasn't reported, therefore he or she has absconded. And there's a difference between absconded, as I understand that term, meaning...
I mean, the warrant is issued, the non-S hasn't been signed, the affidavit hasn't been signed, but the warrant itself has been issued so that the sheriff department can try and find him.
And I think that's what hasn't happened, is that there's been no effort by the sheriff's department to try to find the person. So that you have the warrant, and you have in some instances a backlog of warrants, because as I understand it, in the scheme of things, these warrants are quite appropriately deemed as not quite as pressing as some of the felony warrants that may be out there. So you have warrants that are out there, but there hasn't been an effort to collect the person and bring them back before the court. That's my understanding, sir.
I don't see any more questions, and I want to thank you for
thank you, Mr. Chairman,
taking your time to come up. Sometimes it takes folks like you to bring out the softer side of how things maybe should be. All right, we have two other speakers, and brevity. Stephanie?
Yes, sir.
Woodard?
Yes, sir.
Welcome.
Thank you. I'm here for the Prosecuting Attorneys Council and the Solicitor General's Association. I'm the Solicitor General in Hall County. I just want to make a very few points. One is that this system is as good as the local control and the local oversight. There's no expansion of power here, other than a slight, I'm not sure if it's a typo or a change that I want to address later. The judges have had the authority to use electronic monitoring devices, and I encourage this committee to not be distracted by ideas of limiting it to what appears to be appropriate on the face of the charge. The judges hear the case and the evidence, so they know if what arises out of a truancy issue in my court, where parents aren't getting children to school, and they see a substance abusing parent, and that parent says, please don't put me in jail, please put me on house arrest, and scram monitor me for alcohol or drug abuse usage. That's a much more effective for keeping the family unified, keeping that defendant employed, and monitoring substance abuse. On the face of the charge truancy, one wouldn't think that a electronic monitoring device would be appropriate. But on the facts of the case, as that judge has heard and in his or her discernment deemed to be appropriate punishment, that's not an expansion of power. That's not something that we could think of when we're looking at trying to limit those cases. But it's incredibly appropriate, and we've invested with those jurists the responsibility for looking at those cases. Further, Chairman, I would tell you, I call state court the original problem-solving court. We are not all about the money anymore. There is a vast focus on the traffic citations, of which punishment usually is a fine. But we see much more domestic violence and much more substance abusing. I can tell you that my judges have made changes in their private probation providers and even ultimately come in-house with ours to focus on counseling. Every state court judge will tell you they are much more concerned about whether a defendant is complying with their family violence court-ordered counseling or their rehabilitation with substance abuse counseling than with the payment of any fines. Judge, Chairman, the only thing that I'm concerned about, and we can, excuse me? Yes. Okay. They're going to take care of that typo or that change, and we would urge you to support this legislation and pass it through.
Thank you, Solicitor.
Great.
Hall County?
Yes, sir.
I need to get your card in case I'm passing through there sometime, and I have if I jaywalk, I want to be sure I don't wind up. Sandra Michaels.
Thank you, Mr. Chairman. Sandra Michaels for the Georgia Association of Criminal Defense Lawyers.
I like somebody that starts talking before they get to the mic.
My card is the prosecution card, but maybe I'm wrong. I'd like to say, first of all, Georgia Association of Criminal Defense Lawyers supported the private probation company law from several years ago because anything that could help our clients get home or get back to their families and jobs is important. But, of course, we want to make sure that it's done properly. We have a few concerns with this bill, and I'm going to be brief because I know it's late. But I want to make sure that everyone here understands that there is a huge difference between felony and misdemeanor. Obviously, felony convicted folks need to be under some kind of control. they need to be watched, there need to be certain things going on. We're talking felony of bad checks or the domestic violence that she referenced. But misdemeanors, and if you look in the code section, misdemeanors are like that much. It's jaywalking. It's not having your pet on a leash. It's, I'm sorry to be rude, but peeing in public. There's a variety of misdemeanors that are not appropriate for private probation or that sort of thing. It's not something that people should be paying every month and getting behind or ahead or whatever. And these times, there's concerns, and I know Judge, where was the judge from traffic court that I was here? These surcharges and fees often eat up the actual fine and become far, far more than the actual fine intended, and people get behind and behind. My only concern with this bill, and what I would ask the committee to do, is there are some legitimate concerns about not giving discretion to the judges. They have that. I mean, we all know that, you know, sometimes discretion is abused, but on Section 3 and lines 140 through 17, going, I guess, down to 206, there's certain things that if you look at the vast list of misdemeanor offenses, these conditions, while appropriate for felony convictions, are not really appropriate for all misdemeanors. Is private probation companies abusing things? Sure, sometimes they do. Do judges sometimes not hear all the facts or not really listen to, or you may sometimes abuse the discretion? Sure, of course they do, just like prosecutors do, everyone does. If you have power, it is used. I think a more thoughtful approach under Section 3 would be for a committee to look at some of the misdemeanors and carve out, which I believe one of the legislators was asking, the fines and parts that are associated with misdemeanors, and not use a blanket, what's good for felonies is good for misdemeanors, because that's really not accurate. Again, I do want to clear, I'm not saying I'm opposed to private probation. I think it's very appropriate. And I understand what the bill's intent is, but I'm not sure that what should be painted in a felony barrage should go for misdemeanors also. They're apples and oranges. They're not the same thing. And we would commit to working with any subcommittee, with anyone, to work on maybe narrowing some of these issues and avoid some of the problems that Ms. Garrity had mentioned. Thank you.
Any questions? No questions, and thank you so much. All right, would the author come back? Yeah, you're the author. Yeah, Mr. Chairman.
It's been so long, Mr. Chairman, I wasn't sure.
Well,
Thank you.
Would you I understand the solicitor said that there was a
Yes.
possible change.
In the, when you're dealing with many jurisdictions, there's different ways of looking at things. And if the committee would turn to page 7, line 235, at the appropriate time, we would like to, at the very last word of line 235, strike the word court and replace it with prosecuting agency. That is the way it's currently set up. The court doesn't have that diversion program. It's actually the prosecuting agency. And we've had both the prosecuting attorneys council as well as a state court judge look at that and agree with that.
Well, if I might, like I've repeated, I'm not an attorney. Why would we say that set of court? Because ultimately the court's got to make the decision on any diversion programs, don't they? Don't they do that? Isn't that sort of two to tango? The prosecutors and the judges have to make that decision?
No, sir. That is all done actually in the interest of judicial economy prior to. The only thing that the court rules on currently is the null pros when the prosecuting agency offers it for dismissal. So they're not involved in the structure and the referrals to what services. That is an expansion of power. That is not something the courts currently have. It is with the prosecuting attorney as agency.
If I might ask our counsel, you heard what the distinguished prosecutor said. What say you? All right. What was it? Who?
That was
I'm sorry, who? Deborah Nesbitt? Oh, I just didn't think we could get by one bill without you, Deborah.
Mr. Chairman, thank you. Deborah Nesbitt with ACCG. And in my former life, I did deal with private probation and with the court system. Currently, the solicitor's right, that it is handled that way by the prosecuting attorneys. Those pretrial programs are handled by the prosecuting attorney, both in state court and in any court. So that is the appropriate
so if we
language.
Strike the word court, add what?
And put prosecuting agency.
If anyone wants to know who Deborah Nesbitt is, she may be the only other person in here that can vote for me. So no offense, judges and prosecutors. Her word is a law in here. All right. Do we have any questions from any of the committee members? You have a bill in front of you. Does everyone know what this bill does? Does any committee members have any other questions about this bill? We're talking about private probation.
Mr. Chairman,
We're
we're
talking
talking
about
about
setting
misdemeanor
standards.
probation, public and private.
Well, it is public-private, but it's not state probation, misdemeanor probation.
Right.
How about that? Let me clarify that. I stand corrected. Does everyone understand all the provisions in here? Does everybody understand the importance of getting this process back up and running so that it doesn't collapse? If not, somebody needs to be prepared to find a boatload of money to put Department of Corrections back in the business if this doesn't work. All right. No one is, no questions? We do. Ms. Frazier? No. Finished? All right. Any other questions? What's the will of this committee? We have a motion. We have a second. Do pass by committee substitute, which is LC 287016S. Do we have any subsequent motions? Yes, we do. We will need to amend the substitute on line 235. Strike the word court and add prosecuting agency. Is that correct? Will anyone make that motion?
I'll make that motion.
We have a motion. Do we have a second to that motion? Any questions to that? If not, all in favor of the amendment, say aye. Now, the posture of this committee is you have in front of you LC 287016S as amended by the committee as a committee substitute. We have a motion and we have a second. Do we have any further questions? All in favor say aye. Aye. Opposition? One negative. Ladies and gentlemen, I want to thank y'all for being here today. Thank y'all if it didn't turn out as brief. Before we finish, I've got two things to state to y'all.
Thank you, Mr. Chairman. Appreciate it very much.
We'll be meeting tomorrow from 3 to 4 o'clock for House Bill. I said 3 to 5 o'clock tomorrow. We'll have a hearing tomorrow on House Bill, the first hearing on House Bill 875, Second Amendment bill. I know that y'all have been waiting with bated breath to see this. Secondly, House Bill 907 was assigned to public safety today. This is a bill that I had introduced, and this deals with a public safety issue. Thanks to technology and cell phone technology, we have things called Uber, if I pronounced that right. These are limousines and carriers that you can get an app on your phone and you can call them up. They're in competition with taxis and limos. There's also a secondary class of public conveyance. There's UberX and Lyft and I think 5 or 6 other companies that use apps. These are citizens who want to be taxi drivers and they can be called up on a cell phone. Now my concern with all this technology is not the concern that they're going to drive anybody out of business, i.e. your taxis and limo services as conventional. My concern is a public safety standpoint. One is that if these people who are driving and who are billing themselves out as for hire, Have they passed a screening to be sure that they have no criminal background? Do they have a safe driving record? That's handled under traditional ways. Secondly, when I speak on the other type of driving, the Uber X and the other several different brands, does the public have a right to know that these people have been scrutinized, that they have good character, that they don't have a criminal record, that they've got a good driving record? Do they have liability insurance on their vehicles? Because it is my personal belief, and I understand I may be a dinosaur, but that if the public is paying money for for-hire transportation, they should at least ways know that they don't have a sex offender or a criminal picking up their children or their wives or themselves, unless they want them to be, that that person has liability insurance on that vehicle in the case of an accident, and quite frankly, that they're paying their taxes, the sales taxes that they're supposed to be doing. That's my concern. I understand that we're moving on into the session. I want to be sure that this bill is properly vetted, and I have asked three of the committee members, Representative Taylor, Representative Atwood, Representative Hightower, if there's any other member of this committee that wants to serve with them for the next week, to sit down with powers that be, the limos, the taxis, the Ubers, the Uber X's, the Lyfts, and all of these folks, to work on this, please let me know if you would like to be a part of this. But those are the three representatives that's agreed to study it and work this bill over. That being said, I want to thank everybody for being here today. Hope y'all had an entertaining day of the legislative process, and we hope to see y'all here tomorrow.